obtain financing due to no fault of buyer, notwithstanding section 9C or any other provisions herein, the seller's sole and exclusive remedy shall be to terminate the contract and payment of the escrow by the escrow holder as agreed as liquidated damages. So I was a little ahead of myself there. Okay, appraisal contingency. If either the financing contingency or the appraisal contingency is selected in section 1, the buyer's obligation to close is contingent upon the buyer or its lender, if applicable, receiving an appraisal from a Kentucky certified real estate appraiser establishing that the value of the property is equal to or greater than the purchase price in the following. A, the buyer shall timely order the appraisal, or if applicable, instruct buyer's lender to order the appraisal and take all necessary steps required by lender to order the appraisal before the appraisal order deadline. If the buyer fails to do so, the seller shall be entitled to terminate the contract pursuant to 9C. B, in the event the buyer's appraisal establishes that the value of the property is less than the purchase price, the buyer may, within 48 hours of the receipt of the appraised amount, elect to waive in writing the appraisal contingency, to terminate the contract pursuant to 9A, or give notice of the appraised value to seller. If buyer elects to give notice under 3, the party shall have 48 hours from delivery of such notice to attempt to negotiate as amended purchase price and or payment terms if necessary to close, there being no obligation on behalf of seller to negotiate. If the parties are unable to reach an agreement after 48 hours, either party may terminate this contract pursuant to section 9A. C, if the financing contingency includes an FHA or VA loan under section 1, section 26 is also applicable. Let's turn to section 26. Well, we've got it fresh on our minds here. Okay, and that's
so many sections.
There's
so many sections.
That's the FHA VA sale disclosure, and I think this was changed in here as well. They put that block in there, and it's saying that the buyer shall not be obligated to complete the purchase of the property herein or to incur any penalty by forfeiture of the escrow or otherwise unless the buyer has been given in accordance with FHA or HUD, FHA or VA requirements, a written statement. So that sounds to me like the buyer is going to get their earnest money back if the seller will not do repairs or adjust the price.
And there's no time limit on this. This can just be whenever the appraisal comes back. I think
that's what it sounds like to me. As I say, I was reading a lot of this for the first time last night. I mean, I may have taught this contract, but they've revised it so much, it was crashing around.
Any questions, concerns about that section?
I think this one is easier than it was in the last versions. A lot easier, and it's not the way it was written before. It sounded like you're going to be hung at noon.
But I think in this appraisal contingency section, I mean, it lays out the options the parties have, which we really didn't have before, and it gives specific timelines. So that's something that you're going to have to be real cognizant of when you start getting the appraisal back and going, okay, there's a discrepancy, and then you're probably going to have to refer to this for a while until you get used to what those timelines are, because that's one of our most important jobs, I think, in representing our clients, is keeping them on task so that they don't forfeit anything.
Well, just a note on the appraisal side, like the effective date of the appraisal is the day you look at the property. You may not have the report written for 4 more days after that, then the bank puts it through underwriting. So the buyer might not see that report for a week and a half after the effective date or more. So I don't know how you're gonna prove the 48 hours,
Well, I think it's once received by the buyer, right?
It would be once, but how do you know on the seller side when the buyer received it?
Well, because it usually comes to their emails now, right?
I think if you're representing the buyer, the best thing you can do is tell them they need to get with the loan officer and lock in right away and get that loan officer to order that appraisal immediately, so no more waiting until after the inspections.
And buyers need to know to be on the lookout for that appraisal.
Right.
So when it comes, they're then, if they miss it in their email or they're out of town.
And if you're working with a good listing agent and when you're representing your buyer, you both should be communicating, hey, we got this ordered right away. This is, this new contract. And so that listing agent should also communicate the day they go out. That way you kind of have in your mind. I mean, I always touch base that way.
And I think if you see that you're getting close to that deadline, and even though it says time is of the essence, I think you need to write an addendum extending the deadline on that to protect your client.
You think people will be clicking that a lot, the time of the essence?
That they'll be clicking it.
No, she's talking about
Checking the box.
checking the box. Checking the box?
I wouldn't think
I
so.
hope not.
I wouldn't
I mean,
think
the
so.
goal is to get to the closing table, and both agents' job is to negotiate it to the benefit of really both parties so that you have a meeting of the minds. And this just shows you gotta work together and stay on top of it. And then if you're looking for a way out, you look at the time is of the essence. Okay, let's go back. I mean, I'm just being real world here.
I know.
Okay, where did we leave off?
The due diligence section.
Okay, in the event the buyer does not timely notify seller under section 5B, buyer shall have no further rights under this section 5 and shall be obligated to close unless another section hereunder applies. Okay, due diligence. Unless buyer has affirmatively waived due diligence and inspections in section 1, the buyer shall be entitled to conduct reasonable due diligence and inspections. All inspections and due diligence shall be at buyer's sole cost and expense. It is buyer's sole responsibility to timely conduct all inspections and to conduct due diligence or any matter or issue important to buyer, and if applicable, to request in writing that seller make any repairs before the expiration of the due diligence period. So you've got, this is what we went over over before in the new contract, is if you've got 14 days to get your inspections done, you don't wait until day 12 or 13 to schedule the inspections. You order them on day 1. You order them as soon as possible because you've got to get the inspections negotiated by midnight of that 14th day. I know I had one agent early on call me and say, okay, our inspection due diligence period has already, it's the 14th day. When do I need to, and this, she called me in the evening and she said, so when, how long do we have now to negotiate repairs? And I'm like, well, an hour and 5 minutes, you know. So, and she was like, well, we can't do that. And I said, this is when the two agents.
Simpson Optical.
I'm sorry, I thought I silenced it.
This includes the termite also?
The termite is now included
It's now
in that
included.
due diligence period. Yeah. So, gotta get all of it done. Now,
And if you extend that, what form do you extend
I would,
that
if
on?
you're gonna extend your due diligence
Yeah.
period, I would just use the blank addendum.
Okay.
Yeah. We're up here, let's see, unless, where did I leave off?
This is the due diligence section. I think you
Okay,
got through that.
unless the buyer has affirmatively waived due diligence and inspections in section 1, the buyer shall be entitled to conduct reasonable due diligence and inspections. All inspections and due diligence shall be at buyer's sole cost and expense. It is buyer's sole responsibility to timely conduct all inspections and to conduct due diligence on any matter or issue important to buyer, and if applicable, to request in writing that seller make any repairs before the expiration of the due diligence period. So you gotta get it all negotiated by the end of the 14th day or whatever you set as your due diligence. However, there is no obligation on behalf of seller to make or to agree to make any repairs. In the event the parties are unable to reach a signed written agreement regarding requested repairs before the expiration of the due diligence period, the buyer may terminate the contract pursuant to 9A. In the event the parties agree to such repairs or other terms or conditions, such agreement shall be in writing and signed by the parties, and the repairs agreed to, if any, shall be completed no later than 48 hours before closing. Because you have the right to do your final walkthrough within 48 hours of closing.
Yeah. I was just gonna say, and then this next section, the buyer inspection, that all looks like stuff that was in the contract. Inspectors reports on the repair list
That was
and all
on,
that stuff.
that was on the inspection form
Yeah.
before. Okay, the parties agree to such repairs or other repairs, such agreement shall be in writing, signed by all parties, and the repairs agreed to, if any, buyer inspections, the buyer is entitled to conduct reasonable inspections of the property during the due diligence period. The buyer understands that the seller is not required to bring the property into compliance with the applicable building codes. The seller is not required to perform the repairs listed in an inspector's report or in the seller's disclosure of property condition form, except as may be agreed to or a signed written agreement by the buyer and the seller. The inspector's report is not a repair list. The seller shall not be required to make any repairs or improvements required by buyer's lender. An inspection is recommended on every purchase, and inspectors and appraisals required by lenders, including FHA and VA, do not necessarily eliminate the need for additional inspections to address all issues important to buyer. 2, buyers should use licensed professionals for all inspections. The agent and brokers involved in this contract do not guarantee the performance, competence, qualification, or ability of any vendor, service, or provider that are referred to. Okay, I think that's pretty much the same. 3, the seller shall remove any personal belongings and/or debris that might obstruct a thorough inspection of the property and its improvements both inside and out. If the buyer needs to re-inspect the property as a result of the seller's failure to comply with this provision, the seller shall reimburse the buyer for the reasonable cost to re-inspect the property. Inspections may include, but are not limited to, I can let you read that. Now, pest termite inspection. before the expiration of the due diligence period, or if the due diligence period is waived in section 1, then 7 days from effective date or such other deadline is required by state or federal law, the buyer may obtain and pay for, except where by state or federal law payment is to be made by seller, a wood-destroying insect infestation. So this is different right there from the present contract, because the way it states in our present contract that we've been using is the buyer pays for the termite inspection with the exception of a VA loan. Well, now the veteran can pay for the termite inspection themselves, but because our old contract says differently, we're following what's in our old contract. But this one means the veteran can pay for the termite inspection. Got it? Okay. And I should say wood destroying organisms inspection. Wood destroying organism insect infestation inspection certificate for all of the property and its improvements, signed by a Kentucky certified technician and employed by an insured and Kentucky licensed pest control provider. Said certificate shall clearly indicate that all improvements located on the property were inspected. In the event visible evidence of active wood destroying insects is observed, and provided that treatment and repairs collectively can be made for an amount not to exceed 1% of the purchase price, the seller shall, at seller's sole expense, have such treatment and repairs performed by a qualified professional prior to closing. Seller shall present proof of said treatment and repairs to the buyer as deliverable at closing. So that's not negotiated between buyer and seller. That's in your contract, and the way it presently reads in the exclusive right to sell contract, the listing agreement, it does merge with it, because that says the same. That, like right now, after you do the wood destroying organisms inspection, I have that property in Carlisle had the powder beetles. Yeah, I couldn't remember. It's the first time I've ever had that before, but it had powder beetles. And so I just sent the paperwork to the other agent, and he had to battle it out with his sellers to get them to take care of it. If the cost of treatment and repairs exceed the foregoing amount, the parties shall attempt to negotiate a resolution of the matter, and any such agreement shall be documented in writing and signed by the parties. In the event the parties are unable to reach a signed written agreement regarding requested treatment and repairs before the expiration of the due diligence period, the buyer may terminate this contract pursuant to 9A. In the event the parties agree to such repairs or other terms or conditions, such agreement shall be in writing and signed by the parties, and the repairs agreed to, if any, shall be completed not later than 48 hours before closing. Buyer's termination right. The buyer may terminate the contract at any time and for any reason prior to the expiration of the due diligence period, pursuant to section 9A. Following the expiration of the due diligence period, the buyer may only terminate the contract pursuant to 5B, which is the appraisal contingency, or 7B, which is title. So now we come to title. The seller shall deliver at closing unencumbered good marketable title, subject only to permitted exceptions. Title inspection deadline. Notwithstanding any other deadlines herein, the buyer and its lender, if applicable, shall have until 5 days before the closing date in which to perform a preliminary title inspection. and to obtain a title opinion or an owner's title commitment. Wait a minute.
Sorry.
And a lender's title commitment if applicable. Okay, under the provisions of an ALTA title policy to be dated at or after closing, insuring the buyer and lender if applicable against loss under the provisions of the title policy, subject to the form exclusions and exceptions, the permitted exceptions typically contained in an ALTA title policy. In the event a title defect is discovered, this brings up something else on owner's title insurance. That if you, it's always wise for the seller to get owner's title insurance because it's a one-time fee and it stays with the property